Hey everyone, and welcome back. Today we have an update on Isaac Allen, a sovereign citizen I've covered before. During his Florida hearing, he claimed he understood the judge while repeatedly saying he didn't actually understand what she was explaining. So the hearing had to be rescheduled. When the rescheduled hearing came around, the original judge had a family emergency and a substitute judge took over. Isaac then decided the original judge had abandoned ship and apparently believed he could dismiss his own charges. That didn't work out too well. We're starting with his in-custody appearance after he left the courthouse, failed to appear, and had a bench warrant issued for his arrest. Let's begin.
Your Honor, this is Mr. Allen. He's number 1 on the docket.
Ms. Youssef is here? Okay. Is Mr. Allen's going to be a long proceeding this morning?
It's an appearance on an arrest warrant from last week.
Right.
We were just going to be asking to reinstate the bond and then set to next week or the week afterwards.
Okay. All right, so I will take Mr. Allen now then. The court calls number 1 on the docket, People versus Isaac Allen, 25 CR 3539 entries.
Juan Silva on behalf of the people, on behalf of Ms. Staub.
And Rebecca Landry on behalf of Mr. Allen, who appears in custody.
All right.
Your Honor, we are requesting to quash the warrant that issued and have Mr. Allen's $200 bond that he previously posted reinstated on this case. Mr. Allen had court last week. He was here until 4 o'clock after Your Honor left. I think there was a little bit of confusion because I also left the courtroom to go to 5C and he left the courtroom. What I can tell you is that he has a case in Broomfield right now that he's pro se on and he has a motions hearing tomorrow for it. So we are asking to quash this warrant. He is willing to come back to court in the next 2 weeks and see if we can try and come up with a resolution on this case as well.
All right. Any objection from the district attorney?
Well, I'm going to defer to the court, but I just want to make sure the record's correct, which is I don't think there was confusion. The defendant, while he was walking out of the courtroom, stated the judge abandoned her post and the case is now dismissed, and then walked away.
Right. To be clear, on Thursday, late in the day, I did have a family emergency. And so I had to leave the bench and Judge Egelhoff covered the remainder of my docket. So all cases were heard last Thursday. So I do understand why that was frustrating, but we do what we have to do, which includes staying until your case is called on the docket, even if that is frustrating. So the court will reinstate the bond. The court will reset this matter. Looks like I can set it for March 6th, Friday, March 6th at 8:30 a.m.
That should work. Thank you.
Thank you.
26 is quashed then?
All right, so I will set this, I believe we're still at the arraignment stage. So March 6th at 8:30 a.m. Anything further?
And if we could just make sure that the March 13th show cause hearing is vacated since we're reinstating the bond.
Yes, we will vacate the show cause hearing set for the 13th.
Great. Thank you.
Thank you.
And so, Mr. Allen, you are required to be back here March 6th at 8:30 a.m. If not, I have to issue warrant for your arrest.
I wanted to show that appearance to give you an update on the case and set up another arrest that happens later in this video. Today, we have 2 more appearances to cover, both of which took place within the last few weeks.
25 CR 269, People versus Isaac Allen. Can I have appearances, please?
Katie Wells for the people.
And Mr. Allen, just come up to the podium, state your name. State your appearance, please.
Isaac.
Isaac Allen.
Yeah, I'm Isaac Allen.
Okay, we are set for trial on August 3rd for 3 days. Are the people announcing ready?
Yes, Your Honor, the people are ready.
Okay, Mr. Allen, are you announcing ready to go to trial on August 3rd?
Some papers to.
Answer my question first,
Yes.
please. Okay, so what do you have?
I have some other motions that were for the motions hearing that we had. Some other things that was wrong in that, so
Okay, you can upload those into you can go,
I already submitted them downstairs, so.
you can submit them downstairs.
I already did that.
Okay, I don't have them.
That's why I was gonna give you a copy. if you would
I
like.
know, but why don't you approach? I'll take a look at it. We're beyond motions. Do you have any witnesses available to testify
Yes,
today?
not today.
Okay, Ms. Wells, do you want to address these or make a record on these?
So I guess taking them in turn, Your Honor. So I think one of the issues Mr. Allen is wanting to raise is what he calls late disclosed evidence, which I believe refers to the CBI toxicology report that the people, we received it this week and disclosed it immediately. Given that it was not in our possession or control prior to the date that we received and discovered it, I don't believe there's a Rule 16 or Brady violation. If Mr. Allen needs more time to review the results or challenge those results, the appropriate remedy is a continuance and he can waive speedy. Regarding,
Let's address them one by one.
sorry, Your Honor, go ahead.
So Mr. Allen, with respect to that, did you receive that toxicology?
I haven't received anything from her. Along with the CD that's also being talked about, that was.
Hold on. How is it disclosed, Mr. Allen?
It hasn't been disclosed to me.
I'm not asking you, Mr. Allen, I'm asking Ms. Wells.
Your Honor, I can, it looks like we mailed a letter for additional discovery on the 14th.
Okay, so that's in the works. You're gonna have it. I agree with Ms. Wells that this wasn't something within their possession, and so there's no violation under
So
Rule
there's no violation
16.
of the test.
Would you like more time when you get it to review it?
I'm gonna need more time, yeah, because I mean, what I see right now is 5 months later to have it tested is
Okay.
completely out of scope.
Okay, so with that, so trial's set August 3rd. Are you saying that you're not going to be prepared for trial August
If I don't
3rd?
have this paperwork, no. How would you be prepared if I don't have all of?
Sir, just answer my question, yes or no? So
No.
you're not going to be prepared. Are you asking for a continuance?
I'm not asking for anything. I'm asking for this to be dismissed.
It's not going to be dismissed. Are you asking for a continuance?
Yeah, I'm gonna need one. If I'm-
Okay,
to-
are
to
you
go-
waiving?
I'm not
speedy?
waiving, no, I'm not waiving speedy trial.
Well, that's the only way you get a continuance,
No,
is if
I
you
was
waive.
ready, I was ready on June 22nd before this even came about.
Mr.
Ready.
Mr. Isaac, I'm not going to hash over what we've already gone over. Your options are you get a continuance and that's granted, and speedy will be recalculated at 6 months, and you have to agree to that to get the continuance.
I'm not gonna agree to any of that because.
Okay, then we're going to
not-
trial August 3rd.
That's not part of how the scope works.
We're going to trial August 3rd then. That's your option.
Well, why is that just an option? I mean, I was ready before. I didn't even have.
We're not talking about that.
There's-
Sir,
Did you read the other motion?
we're going to talk about the things here in a very specified order, okay? So it's either we go to trial August 3rd, or you get a continuance, and there is going to be a continuation of speedy for 6 months. Which do you want to take?
Well, I'm gonna need the continuance, but I'm not asking.
And
for
you're waiving speedy to get that continuance.
I don't see why I'd have.
If you want to continue your upcoming jury trial, you may have to waive your speedy trial rights to allow for the delay. You can't demand a speedy trial while also asking for more time to prepare.
Have to waive it to get it.
I guess I'm not, so it's something I have to do. I mean, you guys are just, I'm being forced to do it, so yes, I guess I'll have to do that. I'm not doing. it
Well, I
voluntarily,
can't take
I'm
a
being forced
waiver
to
if
do
you're
it.
saying that you were forced into the waiver.
I'm forced into all this right now. We're coming up with a,
Mr. Okay. What do you
go to the
want,
next thing.
do you want a continuance or not?
Yeah, I'm gonna need one.
And you're going to waive speedy voluntarily to get that continuance.
It wouldn't be, it's still not voluntarily. Because you're not they could have submitted this a long time
All
ago.
right, then we're
It's not-
going to
it's not-
trial
it's not my
August
fault
3rd.
that
We're
she's
going to
negligent.
trial
She's
August 3rd
not
because
my fault she's
speedy
negligent.
currently ends August 27th.
Not my fault that she's negligent.
Okay, let's get to the next motion.
I think the next motion is trying to suppress the legal basis for suppression. The arrest was illegal. We've already litigated that, Your Honor. In terms of field tests being inadmissible and the chain of custody being broken, I would need additional time to respond to those, but I don't believe there's a substantive legal issue that's raised.
Okay. Okay. So the problem with these motions, Mr. Allen, is that they are untimely. They were just given to the prosecution. In order to respond, the prosecution needs more time. I don't know if it would require a testimonial hearing, but do we have time on July 31st to address these motions? And could you do that, Ms. Wells?
I'll say that one of the testimonial motions we were anticipating on proceeding on tomorrow is going to have to be reset until the 31st. So I will be here, but I am already set with other testimonial motions.
Okay.
So
And just looking at this, do you know if you have any witness issues?
I would need to confirm with Officer Mena if he's challenging the arrest. I would need
No, the
testimony.
arrest is that we've already addressed,
Okay.
the illegal arrest. I'm not going to address that.
Okay, then field tests being admissible in chain of custody. I can just respond via a written filing prior to the 31st. I don't think I'll need testimony for that.
Okay. And just for the record, number 3 in this set of motions, the no injured party or verified criminal complaint. I've already addressed the verified criminal complaint. That's denied. The no injured party, that is not a valid.
It can't be a.
That is not a valid objection or basis for dismissal. So that's denied. And your demand for lawful authority, there's no action taken. I have jurisdiction
Yeah, but-
under the U.S. state
How would you have
constitutions and statutes, and I'm not going to hear argument on that. So this will be set over just to address the field test and the chain of custody issues only. And that will be, the motions hearing will be October 31st. And I'm going to give these to you, Krista, July 31st at 10 a.m.
I don't know if I'll be in town.
Well, that's the only chance you have. So you're not telling me,
You could totally.
you are not telling me you have a conflict at this time, Mr. Allen. July 30th at 10:30, we're going to go over the rest of the pretrial stuff. It's still 3 days, Ms. Wells, or do you think it's less?
I don't expect needing more than 1 day for evidence and testimony. I'm not sure what.
But she said I'm sorry.
No, that's okay.
She said there's something already set. Well, I'm going to have to do it. Just so you know, I have a conflict with July 30th that I'm putting aside to accommodate you. So I expect you, because this is your case, to not make any travel plans and be out of town on that date. So we'll see you on July 30th at 10.
Oh, you'll definitely see him. You'll see him run his mouth, disrespect the court, and eventually get arrested for his behavior.
Next, number of jurors to call. Ms. Wells, our usual is 55.
I think that's fine. Your
We'll
Honor.
call 55 jurors. The regular questionnaire will go out. You can get a copy of that, Mr. Allen. Time for questioning jurors in voir dire. Ms. Wells,
25 minutes.
are you asking, would you like 25 minutes to question the jurors during jury selection?
Yeah.
No?
I said yes.
Okay, well, you need to speak up, please. 25 minutes per side for voir dire. Opening statements,
10 minutes, 5 minutes, really.
we'll do 10, just in case. Do you want anything more than 10 minutes? 10 minutes per side for opening statements. Jury questions of witnesses during trial. Ms. Wells, what's your position?
I would ask for no jury questions.
I would ask for jury questions.
Okay. I'm going to take that one under advisement. I'll let you know on the first day of trial whether those will be allowed. Jury instructions, when can you get them filed, Ms. Wells?
I can have them filed by end of day tomorrow, Your Honor.
Okay, those are due.
Yeah, I can have them filed by end of day today. They're ready. I just need to file them.
Okay. I'll give you till July, or no, what week is this? July 17th, end of day.
Thank you.
And then you'll get a copy of those mailed to you. Or you can come pick up those jury instructions. If you have any additional ones to submit, you can submit them on the morning of trial or during trial. We're going to go over protocol for trials. I know you've been in a trial, Mr. Allen, but you have not, I don't know if you've represented yourself or not, so we're going to go over those the morning of trial. If you have any exhibits that, or an evidence you'd like to submit, just make sure you have a copy for the court reporter, a copy for Ms. Wells, and a copy for me, and that they're marked appropriately using letters, not numbers. Do any witnesses require interpreters?
None of mine do, Your Honor.
No.
Okay. I also want you to give me a name on the first day of trial, Mr. Allen, a list of any witnesses you think you might call, so I can read them to the jury and make sure the jurors don't know any of your witnesses. I'll be reading them the list of witnesses Ms. Wells provides me as well. Do you understand that?
Yep.
Okay. Sequestration order in place. I'm going to order that sua sponte. Okay, I think that's all we need to go over today. So you will be here July 30th at 10:30
July
and then,
31st, you said, not July 30th. I won't be even in town. I'll be flying back.
sorry,
today.
July 31st. Sorry,
Was that at 10 or 10:30, Your Honor? Thank you.
10:30. And the first day of trial, I'll remind you at that time again on July 31st, but first day of trial, you need to be here at 9 o'clock, ready to go. Okay, anything further, Ms. Wells?
Nothing additional from me, Your
Okay,
Honor.
anything further?
You can
Mr.
totally, I'll let you totally the thing, but I won't waive my speedy. You can totally the speedy, but not waive it. I will not waive it. Tolling it's fine.
Well, it actually, okay. Now we need to go
Because I
back
mean,
to
I'm
that.
gonna need more information. I got vacation coming. I'm going to Las Vegas for my daughter's 21st birthday. So
So what? Do you really think the court is going to prioritize your upcoming trip to Las Vegas over your criminal case? If the trip conflicts with your court obligations, it might be wiser to reschedule it rather than risk missing even more time with your daughter.
Okay, I'm actually looking back at the statute, and I don't know if this is changed by case law, but it says if a trial date's been fixed by the court and the defendant requests and is granted a continuance, the period within which the trial shall be extended for an additional 6-month period from the date upon which the continuance was granted.
you also need all the officers' logs too, for when he said he checked my background before he even.
We're not addressing any other issues right now, Mr. Allen.
I'll file it then. I'll
We're
file it.
pausing on Speedy.
So, Your Honor, the information that I'm receiving is that by the plain language of the statute, tolling is not an option. It has to be a waiver. But if he requests and is granted a continuance and it is extended by 6 months and the waiver is an operation of law. I don't believe he has to give an express verbal waiver. I think it's just an operation of law if he requests a continuance and the court grants it.
Although I'm concerned about the carve out when it's not chargeable to him, even though he's requesting it, because it's chargeable to the disclosure of the recent materials.
Yes, but there's also time between now and trial that he could review those materials and follow up. So
That's true.
that's my position.
Okay. All right. So we're going forward with our trial date. We'll see you on July 31st at 10:30.
All right.
All right, that's the end of his first hearing. Now we move on to his next hearing, which took place on July 31st. And let's just say he didn't exactly make the best impression. He showed up late. So the judge issued a bench warrant and forfeited his bond.
Okay, I'm going to call 25 CR 269 People versus Isaac Allen. Can I have appearances from the people?
Katie Wells for the people.
And I will note that Mr. Allen does not appear today. We were set for 10:30 a.m. For pretrial conference and an additional, we're going to address some additional filings he had. He was present in court on July 16th, and it was reiterated to him that his appearance was necessary today at 10:30 a.m. It is now almost 10:55 and he does not appear. Ms. Wells.
Thank you, Your Honor. I'm asking that the court revoke the personal recognizance bond, and I'm asking the court to actually set a no bond hold in this matter. We are set for trial on Monday and the people are ready to go. And I'm concerned with his non-failure to appear today. If he's picked up in custody and is able to post a bond, that he also won't appear on Monday morning either. If the court is not inclined to set a no bond hold, I would ask that the court impose a cash only bond, a high cash only bond.
Okay. I'm not inclined to set the no bond hold. If he fails to appear Monday, there'll be other actions to be taken. And even issuing the no bond hold, well, either way, the jury has to come Monday morning. So it doesn't solve any juror issues. Unfortunately, if he does not appear, it's certainly a waste of the juror's time. If we issue a no bond hold, it's unlikely we're going to get notice that he's been detained in time to cancel the jury. So that still doesn't save those resources.
Understood, Your Honor.
I know there might be some practical reasons for the no bond hold, but he has appeared mostly on other dates.
Understood.
So I will issue a bench warrant, and I will issue that in the amount of the prior surety bond was $2,000 cash or surety. So I'm going to issue the bond in $4,000 cash only. And we'll see what happens Monday morning.
Sounds good, Your Honor.
Well, a lot is going to happen before Monday morning, starting with him finally showing up to court on July 31st, 45 minutes late for his motions hearing.
Okay, I'm going to recall case 25 CR 269, People versus Allen. Can I have appearances, please?
Katie Wells for the people.
Mr. Allen, state your name into the microphone, please.
I'm here.
No, state your name. I'm here doesn't work.
I'm Alan.
Full name.
You don't say her last name.
State your full name. Mr. Allen,
You know who I am?
I've directed you to state your full name. This proceeding is being audio recorded, and we need to get a good record. That includes an appearance.
I'm the indigenous Isaac Allen.
Right. Let the record reflect there's a current active bench warrant for Mr. Allen for his failure to appear at 10:30 this morning. Given his reappearance and your availability, Ms. Wells, how would you like me to proceed?
I'm asking that the court find a failure to appear and remand Mr. Allen. I understand there are issues to litigate, but Mr. Allen had notice and the opportunity to show up on time. He failed to do so, and I'm asking that the court remand him as a result.
I got out there off the airport at 9 o'clock. My airplane landed this morning, so I told you guys I was going out of town.
Yeah, no, Mr. Allen, I will tell you what you were told on July 16th, that we were resetting this for 10:30 today. You had responded that you might be out of town. And I told you that you better prioritize because I was coming in, even though I had a conflict on my schedule, and you have now kept everyone waiting 45 minutes. So you don't get to choose what time you appear in court.
I do what I could to get here as fast as I could.
You did not do what you could to get here.
If my airplane,
Tell me why you needed to be out of town.
because it was my daughter's birthday. It was her 21st birthday, that's why.
Yeah, that's not reason.
Yes, that's reason enough for me.
Yeah.
And you only have one daughter, what would you do? If you only have one daughter, that's where she wants to go.
I would prioritize my penal interests and get to court.
Well,
So,
I'm here.
I'm considering remanding you into custody because of your obvious and intentional disregard of my court orders.
No, I respect it very much. I tried to get her as fast as I could. I mean,
No, you were ordered to be here at 10:30 and
I-
you didn't, and you chose to go out of town and get on a plane
let's
and
go to-
arrive at 9 o'clock, which I still don't understand how you couldn't get here by 10:30 from
that's
the
you talking
airport.
for your baggage luggage? I mean, I had my son come pick me up. I mean,
Mr. Allen, do you understand that I'm not interested in
well, but let's.
why you chose your personal life over court orders?
Personal life is over court. My life is, this is nonsense. This right here is nonsense, as what I see it. I
All
mean,
right,
right now,
take a
the
seat. Take a seat.
district attorney can't even prove the case.
Take a seat.
Let's go over the matters at hand. We're wasting time now, right?
You're wasting everyone's time, and that kind of behavior could end up costing you in the long run.
Okay, we're still on the record in 25 CR 269. I've taken the prosecution's request into consideration and under advisement. And given the fact that we have some substantive issues to address today, if I remand the defendant, we're going to have to address those Monday morning, thereby further wasting time of other individuals, in addition to the time that's been wasted at the behest of Mr. Allen today of everyone else. So I reluctantly am going to quash the warrant. The PR bond is reinstated, and we are going to trial Monday morning. Mr. Allen, you need to hear me and hear me clear. Well, first of all, I'm going to attach a monetary amount to the PR bond. I'm going to increase.
I'm on a PR bond in this case.
Oh, you're on a 2,000 cash surety. Okay, I'll reinstate that cash surety bond that was forfeited today. Yeah. And I'm going to make it very clear. You were ordered to be here at 9 o'clock on Monday. That does not mean 9:01 or 9:02 or 9:05 or any time thereafter. If you're not here at 9 o'clock, a bench warrant will issue. The jury will be sent home, and that bench warrant will go active immediately. Do you understand that?
I hear you.
And if you fail to appear Monday, that bench warrant will go active with a $4,000 cash only bond attached to it. So with that, we need to address, I just want to, for the record, there's several motions that have been filed. I'm going to talk about the notice, which includes the motion to suppress, filed on July 22nd, 2026. There's two, as far as I can see, two motions and requests, including in there the unlawful stop and search. That's denied for the same reasons all of the other motions have been denied. There's a re-request for discovery. Ms. Wells, I'm not sure if this is the same request as prior discovery, but can you address those?
Is this as to the motions filed on July 28th, Your Honor?
22nd.
I did confirm, though, with our support staff that any discovery has been sent, any and all discovery has been sent to Mr. Allen.
No,
I can
but-
make a further record in just one moment.
I have a blank CD to prove that she did not. So I came in here and picked up the CD that she said was supposed to be the.
Mr. Allen, let me tell you how I want this to work. When I call on you, that's when I want you to tell me your position. But right now I'm listening to Ms. Wells, and she's reviewing her information so she can give me more information. Please do not interrupt.
Okay, so Your Honor, it sounds like when the CBI report was received, that was the new evidence that we mailed Mr. Allen notice of, and that we wanted, or that he, I think, intended to come pick up. It sounds like the new evidence was only that report and nothing in Axon or evidence.com needed to be updated. So that might be why the disk was blank. In any event, I can print a copy and hand it to Mr. Allen today. Or, I mean, if that's the remedy the court would prefer, I can do that. That's the quickest way, I think, to get him whatever he's alleging he's missing.
Okay, so that would be the report itself.
Yes.
Do you have the report itself, Mr. Allen?
No. I
Okay.
don't have anything that she sent me, and that's all, it's all circumstantial evidence now anyways.
All I asked was yes or no.
No, I don't have
Okay.
anything that she's
Please-
supposed to send. in
Please
email.
have that printed, Ms. Wells, and you can provide it to Mr. Allen. But actually, I need you to turn to the notice. of July 22nd. It's filed notice, but it's actually a motion.
Mhm.
And there's requests for discovery and inspection. Well, first of all, let me handle some of these. Some of this is for body worn camera footage on the date. This is regarding the date of the incident at 6600 West 120th Avenue?
Yes, Your Honor.
Okay, and that's been provided?
Yes, Your Honor.
Okay. I don't know what a magical CD is. Mr. Allen, do you want to respond?
Yeah, she held it up in the court during motions hearings that she had a new CD that had all this information on it from the officer testifying that he had all the CAD report and all that other shit that she said.
Okay, watch your language, or you're going to be held in contempt. Do you understand that? That
Freedom of
disrespects the
speech.
dignity of this court. Watch your language.
Freedom of speech.
Nope.
No person can be deprived of her right.
You should probably tell that to everyone sitting in prison, where their freedom of movement has been restricted as a direct consequence of their convictions.
Mr. Allen, are you begging to be held in contempt of court?
I'm just saying.
I suggest that you use respectful language. All right, so I'm going to accept the district attorney's statement that all body worn camera footage and dash cam footage, if available, has been provided. The dispatch audio and CAD logs, this relates to the arrest itself. I don't see how that is relevant to the issues left for trial. This seems more relevant to the suppression issues which have been decided. But Ms. Wells,
Those have also been discovered, Your Honor.
okay, those have been discovered. The prior altercation, the search and basis of scope, that again, it seems irrelevant in terms of the issues at trial, because these were reasons for the stop and the search. Ms. Wells, do you have any record to make on that?
I don't, Your Honor.
Okay. The photographs requested are for plate, steering column, interior vehicle condition. Again, I don't understand how that's relevant to, I don't understand how that's relevant to the issues remaining at trial. That appears to me to go to the
Judicial notice.
suppression issues. How is it relevant to the elements the prosecution has to prove in this case? Mr. Allen.
Well, because you had an officer sit up here and testify that this is what really happened, which that's not exactly what happened. If that was the case, why do you wait 1.7 miles to pull me over? I mean, what he's trying to say and what he said, and that I matched some previous guy, that's all circumstantial. That's going off a hunch.
All right, so I'm going to find, based on the statements of Mr. Allen, this relates more to the suppression issue, which already has been decided, and I'm not going to order any disclosure.
Yeah, this is
The drug testing documentation will address in the other motion. The field, well, no, we won't. We'll address it here.
Well, there's other
The
news.
field test documentation, the DA has already indicated that they don't intend to admit it. You filed a motion to suppress that. I'm granting that. That means no party can introduce any evidence of any field testing. That was based on your motion.
There's no field testing and there's no drugs whatsoever. I shouldn't have been arrested in the first place.
Mr. Allen?
Before it again.
Mr. Allen, it's
Understand.
not your turn to speak.
Mm.
The lab test documentation, that's what's already been provided.
No,
and
it
Ms.
has
Wells
not.
is going to give you another copy today.
There's not.
So that takes care of that
She
motion.
mailed me a letter.
Then we have the
No,
motion to
it's BS.
suppress filed on July 16th.
Bullshit.
I already denied the first portion, the suppression issue. The field test we've already spoken about, and that is inadmissible by any party, including you,
No,
Mr.
I
Allen.
want that to be missed. I want that to be able to be missed, because if that's,
You moved to suppress it
then if there's.
on the grounds that it wasn't admissible.
If you can't, then
that
the
you
drug.
can Stop
then the drug-
interrupting me.
The drug shouldn't be done either. The drug shouldn't be done.
I'll be back.
That ain't admitted, the drug should not be admitted. It's not due process of law.
All right, this is where the judge starts losing patience with him. She briefly stepped away, and when she returned, she forgot to turn her microphone back on right away. So we get to hear her admonish him for his disrespect toward the court mid-sentence once the mic finally comes back on.
In direct contempt of this court, and there will be a punitive sanction, which will be remand into the custody of the Broomfield Police. So this is your warning. Please do not speak over me. Please do not speak over the district attorney. Do not disobey my orders when I ask you to do anything in this courtroom. Failure to do so is going to end up in a direct citation for direct contempt. So let me proceed. We've already addressed the field tests. It was your motion, Mr. Allen, to exclude any field testing in this matter. The DA agreed that field testing is not admissible at trial in this case under the rules and laws of Colorado. So the order of this court is that field tests and any reference to field tests is not admissible by any party at trial. With respect to the chain of custody issue, the district attorney provided documents reflecting that chain of custody. Your arguments, Mr. Allen, appear to me to go to the reliability of that chain of custody, which goes to the weight of the evidence, not its admissibility. I will give you the opportunity to make a brief statement on the chain of custody issue. What would you like to say?
Chain of custody, I've never, any evidence that's submitted 30 days before, prior to any trial is all inadmissible in the U.S. Colorado state statutes or your codes. The blank CD and what should have been on it is not even on it at all. She has a list of what was supposed to be on here. There's nothing on it whatsoever.
Are you talking
And
about the CD? I don't think
this is the CD that
Mr. Allen?
you asked me
no,
to speak, and I'm trying to
I
explain
know,
it to you.
I know. But when I start speaking, you need to listen because we're going off on a tangent and I want to redirect you. The chain of custody evidence was in paper form attached to the pleading.
No.
It was not on a CD, correct, Ms. Wells?
Nope.
It was, I believe it was an exhibit to this motion because I reviewed it and looked at it.
Yes, and those have both been discovered to Mr.
Okay.
Allen.
No,
There's nothing that has to do with a CD with respect to that. So with respect to the chain of custody, you've made your record in the fact that you believe it wasn't on the CD. I've told you it didn't need to be on a CD because it was part of a paper pleading and given to you.
She did not
Do
send.
you have anything else to say?
Yes, she did not send it to me. She sent me a letter saying I could pick up the evidence and on a CD. That's what she told me to say in the letter. I have the letter still today for that's what she said. She didn't send me nothing in the mail like she said she stated in court on motions hearing. She said she sent me the lab report. I have not seen a lab report whatsoever.
Hold
not
on,
once.
we're not talking about the lab report. We're talking about the
Well, the
chain of custody
chain of custody-
documentation. Now you're done, Ms. Wells.
You
Do you have excuse me?
I said, well, I'm talking to myself.
No, you're talking out loud into a microphone.
Well,
Ms. Wells, when did you provide the chain of custody information and how?
It was discovered with bait numbers 120 through 125 and 126.
And
I'm confirming how those were provided.
and
Your Honor.
when? And in any event, I'm submitting the evidence submitted receipt. I'm printing it out for Mr. Allen right now.
that's
In any event, I'm going to deny the motion to suppress the talks reports due to any chain of custody issues. That's denied. The motion to suppress on July 28th was already denied. The motion to preserve the body-worn camera videos was also denied. And the motion to dismiss for speedy trial violations was also denied, and written orders were issued in that regard. That's it for motion.
Okay, that's the end of the portion addressing his motions. But apparently, being out of custody wasn't enough for him, because he's about to do everything possible to turn his situation into one where he's back behind
Now we
bars.
need to get to the pretrial stage of this matter.
this is
People announcing ready to proceed
Following.
Monday.
Yes, Your Honor.
Is defendant announcing ready to proceed?
no, I'm not going to proceed because this is all, I'm going to have to go above you guys. These go to the federal, this is BS. This is totally wrong. What you just stated is completely wrong.
Sir,
The day you got, the day I got.
Mr. Allen, I'm asking you to stop talking And this is not the day to argue the merits of the case. That's what the trial is for on Monday.
No,
So,
that's not gonna happen.
well, then you need to give a waiver of speedy.
I'm not gonna do that. You already threatened, you already violated my rights on that. You've already violated my rights on that
No,
speedy
I
trial.
didn't.
Yes, you did by
Okay.
threatening me to do it.
We are going forward on Monday.
Okay, that's fine, that's
for a
fine.
jury
Just so no
trial.
one else will be-
Stop talking.
I wasn't done talking yet. You can talk over me, but I can't talk over me.
Yes, I can.
Okay, so that's disrespectful. Either way.
All right. I'm going to find that Mr. Allen has been consistently combative in court today. He has refused to follow the directions of the court. He was disdainful of the court when he was 45 minutes late. He continues to talk over the court. He has made statements after I warned him and gave him essentially an opportunity to change his behaviors. The behavior is not only disrespectful to the court, it's disrespectful to everyone in this courtroom, and it's disrespectful to the judicial system. I don't believe that I think the conduct is offensive to the authority and the dignity of the court. I'm concerned about Mr. Allen's ability to refrain from continuing to engage in such conduct. I'm inclined to impose sanctions here, as I've already indicated, which is a remand into jail. You have the right to make a statement in mitigation before I issue that order. Would you like to make a statement?
Your Honor, I'm not trying to disrespect the court, but what I'm saying is, you asked her a question, she didn't come up with the
Hold
answer
on.
of what she said, what time, when she got this paperwork to me. This is the first time I've ever seen this paperwork.
But sir,
But I'm
the
just saying-
problem is
I'm not
that
gonna.
you were not following my directions. Would you like to make a statement in mitigation such as an apology?
Yeah, I apologize to the court, but you gotta
Are you
understand.
going to?
I just did.
Was it really?
Yes.
All right, you get one more shot. And then you're getting remanded. Do you understand that? So we are going to trial Monday. You have not given a voluntary waiver of speedy. You have been provided information with enough time to proceed to trial. So you need to be here at 9 o'clock. 1 minute late and a bench warrant issues, given your conduct today. In fact, that you were very, you didn't seem to care to follow the timeline that was imposed. In any event, let's talk about trial. So, with respect to trial, and I will tell you, Mr. Allen, if this behavior occurs in front of the jury, again, you will get a warning. And if you can't follow that warning, you will be removed from the courtroom if you disrupt the proceedings. We'll set up a place for you so you can appear by WebEx. But if you are disrupting the dignity of the jury trial and this court, you will be removed from the courtroom during the trial. So with respect to pretrial, how much time for voir dire are you requesting?
I would ask for 25 minutes, Your Honor.
Okay. Would you like 25 minutes to ask questions of the jurors, Mr. Allen? Yes or no?
I still have a problem with the issue before. I mean, you granted something that doesn't even make any sense. The time and date on it isn't the same. I got it.
Mr. Allen,
This is ludicrous. This is ludicrous right now.
I
trying to keep my-
agree.
It's ludicrous. I mean, there's
I agree.
25 minutes. Sure, we'll do.
Are you
25
going to stop
25
talking?
minutes is fine.
All right.
You just
I'm
asked
going
me
to find
25
that
minutes.
the defendant is in
Just asked
contempt
me
of
25
court.
minutes. 25 minutes is fine, I said.
I'm going to order the defendant remanded into the custody of the Broomfield Police. And
This is not due process of law. Just calm down. Let me get my stuff to my son.
we will set the return date on the contempt at 9 a.m. Monday morning, at which point you'll be advised.
Your Honor, can I speak to, I say one thing, Your Honor?
Nope. I gave you
No,
I gave you at least 2 opportunities.
Your time to speak is over.
Okay, let me get my stuff.
All right, that's the end of today's video. I tried to stick around and see if his trial would be live streamed, but unfortunately it wasn't. So we'll have to wait for an official update to find out how the drug charges turned out. That said, given his history of courtroom antics, I wouldn't be surprised if we see him back in court again. If you enjoyed the video, hit the like button, leave a comment, and subscribe with notifications on so you don't miss any future courtroom coverage.